The next case is State of Ohio versus Ahmere D.M. Williams. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are prepared to proceed when you are.
Good morning. Thank you, Judge. I'd like to ask for 5 minutes in rebuttal for reserve. May it please the court. My name is Rick Raley, and I'm appearing today on behalf of the appellant in the case of State of Ohio, which is a bit unusual for me. This is quite a unique appeal. I believe this is the first time in decades that my office has appealed in the middle of a criminal trial. But the circumstances of that trial forced the state to take this extraordinary step today. And I ask that you reverse the trial court's order in this case in which she refused to compel a critical eyewitness's testimony. I ask that you remand it so that the trial court can continue with the trial with the witness being compelled to testify. Before we get into the particular legal, there is a jurisdictional issue here too that I think we could address during our questioning. I do think it is important to summarize the basic facts of the offenses that give rise to the charges here. And that is there was a murder outside of an apartment complex in Akron. The victim in the case drove with 3 other individuals to a complex. One is the witness that we're here for today. One's another witness who is not the subject of the appeal, but also that testimony was excluded as well under similar circumstances, as well as the cousin of the witness involved today. When they arrived at that complex, 2 of the people got out of the car, including the witness in our case, went into the complex while the victim and the cousin stayed in the car. Individuals came out, opened fire on the car. TA is shot and is killed. The other individual, there's a bullet wound that grazes him. There's some evidence that ties this defendant to these offenses. The most important is probably the critical evidence of the witness. He identifies Mr. Williams as a shooter. He identified Mr. Williams in the photo array. As we get closer to trial, he starts to be apprehensive about testifying, essentially. And there are some developments that are addressed before the trial even begins that he may not want to testify. He may be called as a court's witness due to other circumstances. And at that time, the trial judge does appoint an attorney for Mr. Penson Willis, the witness. So he is called to the stand. And at first, when he is called to the stand, he says, "I'm going to answer your questions." And then he starts changing that story. He starts saying, "I'm going to invoke my right." And I think that I believe when I went through, I saw 4 different reasons for why he was invoking his right. First, he said, "I'm doing it because it's my right." Then he says, "I don't want to be involved with this." Then he says, "I fear for my family and my safety." And at that point...
But doesn't he also have a lawyer there expressing that he's fearful of being implicated in the murder by just being present?
So...
That's not him speaking directly, but what's he supposed to say? "Well, I'm afraid because I did this."
Right.
The probably instruction was for him to not say anything about it and to let his attorney speak on that.
So his attorney does speak, and the attorney says there's this immunity offer that isn't going to subject him to additional charges. And when he's asked directly, "Why are you invoking your right?" finally...
But is he even granted immunity here if you exclude murder?
So he was not...
We're talking about a murder trial, where the fear expressed was that he could be charged under some theory of complicity.
So...
Is there really immunity here?
So there was not immunity granted. At that time, the written exclusion of murder came after there was the initial discussion in court, which is a little weird procedural aspect of this as well. I will tell you that there were murder and felonious assault charges here. There was murder that was excluded in the immunity agreement, not because of any fear about there is any actual self-incrimination issue here. And the evidence that the state has reviewed does not implicate this witness at all. And I think that there's great black letter law that just merely being at a crime scene is not sufficient to support criminal liability for an offense.
There's lots of people who are at a crime scene who get indicted on a complicity theory or some theory of they were committing a felony and there was a subsequent murder.
So there would be some other facts that if that has existed, I'm pretty sure he'd be indicted. That is not what we've seen here.
Isn't the law here that the judge does not have to force him to testify unless transactional immunity is granted?
So
do you think this is really a grant of transactional immunity if you exclude murder and you add in dates?
I don't think that the trial court got to that point because it refused to grant a period. So I really don't think it's an immunity case. I think that's an issue that comes at the end. What I'm really challenging is the process that starts before that and the invocation of what he says for why he's doing it. And I think that there were multiple opportunities. First of all, I think it was improper for how the trial judge conducted this. First of all, although it was outside of the presence of the jury, it was not done in camera. There is case law that it is best to do this while you were in camera. On top of that, she allowed both the prosecutor in the case and the defense lawyer to argue about that invocation in front of the witness. It wasn't done at sidebar. I mean, I think that there's a tremendous risk.
You know, I saw some of the things, obviously read them, what you were alleging that was improperly done, like the defense counsel, obviously that doesn't represent the witness and the defendant who doesn't have standing, said, you know, he probably needs an attorney or something like that to the words to that fact. But how do we unring that now? Because even if we would reverse the court, we'd be back in the same spot with that.
I would hope that the months would have, you know, changed around some thinking. I don't know. I don't know how we unring the bell, unfortunately. I know that we really should not say that this was a proper procedure. I do not think that was proper.
Let me ask you, because there's so much here and there's only 15 minutes. What about, there wasn't a lot of discussion in either of the briefs about the statement that was made by the witness beforehand.
What the initial statement was, is that what you referred to, Judge?
Well, I think that he made a statement that that the defendant killed that person, right? Or killed the victim.
That is yes.
Okay.
Correct.
So at that point, he was not under arrest. So he didn't have any Miranda, he was no argument he was in custody or anything at that point.
I honestly don't know that.
Okay.
I don't.
I'm just wondering, because it seems like neither side really cared about that statement, and I'm thinking, why?
Well, it's not that we don't care about the statement, it's that we need him to testify to what he said and what he identified in the photo array.
Right, but I guess and this is maybe something to ask the appellee too, but I'll ask you both. But what if, instead of just doing a blanket Fifth Amendment immunity, but they were question by question, and he was just asked, you know, did you make a statement to the police?
That is another procedure that would have been more appropriate, and I think I cite to that case law about question by question is also the appropriate way to go about it.
And so if he then it says, I claim the Fifth Amendment, then the judge would have to make a determination as to whether or not that was actually protected by the Fifth
Correct.
Amendment. And I'm trying to figure out how that would be protected by the Fifth Amendment.
And I think that goes to the
So
heart.
I'm going to ask them that too. You're put on notice.
That is the crux of the problem here. The procedure was just so improper based on what the guidance is. And that procedure leads to a bad conclusion, that there isn't a legitimate invocation, and we're not going to force him to testify. And I really do think the last part of it too is the last thing that the defendant says is, so why are you doing this? He says, I don't know. Other cases, this, I don't know.
Well, he did eventually, though, say.
That's the last thing that he says, Judge. He does say, I fear for additional charges, and then the judge says, what additional charges? And he says, I don't know. That's the last thing he
Isn't
says.
him, if you went by question, isn't him being there potentially incriminating, and isn't him saying he talked to the police after the event incriminating?
I would,
I mean, what question other than his name wouldn't be incriminating?
Judge, I think that there's clear law that if you are at present at a crime scene, that does not create liability. So I do
If
not.
that's the case.
That I judge that is the case, and that is what the record reflects right now. In the state's written motion, it says we do not have any evidence that attaches him to this murder. It says there's no new or additional evidence on that point.
Unless he speaks about that.
Based on his initial statement, no. And I would also just say there is a red herring here about federal charges. I think there's clear law on that too, that when you are granted immunity and you're compelled to testify, that binds the federal government as well. I cite to the Neff case from the 3rd District, which I think is very helpful. It's very similar circumstances.
Well, that leads me to my original question. Is he really granted immunity if there's an exclusion?
So he was not granted immunity. I think that he should have been. The state requested it, and it was not ordered. It was also ordered that he legitimately invoked it. So I do think that, if you get to that point, but the fact of the matter is we follow such a horrible procedure beforehand, and then he's ordered, the state's restricted from asking any questions, that it ends this, and the critical eyewitness to a murder is excluded from testifying. So that's why we're here today. I think I'm coming up on my rebuttal time, so I'll leave for my counsel. Co-counsel. Sorry, opposing counsel.
We knew it.
Good morning, Your Honors. I'm Marie DeCola, and I represent the appellee Amir Williams. I agree with Mr. Raley that this case comes across really complicated, both legally and factually, but at its core, the law is very straightforward, and the relief that the state is requesting does not exist.
Well, let me ask you this, because one of the first things that I thought of when I was reading everything was the precedence that this sets too in regard to eyewitnesses to crimes. Because I don't think there's any argument that he wasn't there and he made a statement, right?
Correct.
And so what would prevent any eyewitness at any crime make a statement to police and then just come and say, I want to plead the Fifth Amendment?
So in this case, Your Honor, the witness, Mr. Penson Willis, in 2023, right after the crime, said that he identified Mr. Williams as a shooter. The day before trial, he alerted the prosecutors that he lied when he said that.
And that's common practice.
Sure. So I think what it really boils down to is that when a third-party witness invokes the Fifth Amendment right not to incriminate themselves on the stand, that invocation is their invocation alone. And
that's my point.
right.
If that's the case, then what precedence that set for the prosecution? They have somebody that says, I was there, I saw it, and this guy killed this person. And then, for whatever reason, then decides to invoke the Fifth Amendment. I mean, how can you prosecute cases? You rely on eyewitnesses every day.
I think that there is a remedy for prosecuting a case in that situation, and it is the state's remedy, and it is to offer immunity that is coextensive with the Fifth Amendment.
What about the state saying that if they offered him immunity, he could get in there? Especially, seems like the allegation here is somebody got to him. I don't know what's true and what's not. It doesn't matter. But let's just say it's a situation where somebody got to the witness. Okay, I'm not saying that's what happened. I'm just saying. And then he takes the stand and he says Fifth Amendment, and the state says, well, the only way we can get him to testify is if we grant him immunity, which includes murder. So then he gets on the stand like the state said and said, I'm the one that murdered him. The defendant has to walk, and so does the witness.
Honestly, Your Honor, I think that is a problem that, again, the remedy is in the state's hands. It's who they decide to prosecute cases against. It is where the investigation leads them. And
in this case, they had an eyewitness.
Well, in this case, I think the facts that were uncontested that came out in trial were that this witness, Mr. Penson Willis, could have been implicated in this murder. He drove the victim there. The victim did not want to go there. The witness, Mr. Penson Willis, drove them there anyway. The victim was crouching down in the back seat trying to avoid being seen by the group of people. Mr. Penson Willis leaves the victim in the car and joins that big group of people that the victim's hiding from. And then shortly thereafter, 4 individuals emerge from that group of people that Mr. Penson Willis is in and start firing shots at the vehicle. I think that as a defense attorney, and as all of us as attorneys or judges have seen people charged with murder or complicity to murder on facts much less than that.
I understand, but I guess my point is he still made a statement to the police originally.
Correct, and the way that the prosecutors can secure that testimony at trial is to offer him full immunity. And the trial court in this case could not compel him to testify under the terms of the state's immunity
So
agreement.
what is the answer to what precedents we're setting? That's what I'm concerned about. So anybody can take the stand and say, well, I did it. And then everybody walks.
I think that the precedent that will be set that if the state is allowed to pause in the middle of a jury trial, time out, jury's been impaneled, they've heard witnesses testify. The trial court heard witnesses testify that implicate Mr. Penson Willis. This invocation was not speculative, and that's kind of the point of the Fifth Amendment invocation. It is a constitutional privilege, but it is not absolute. There has to be a grounded fear of self-incrimination. And if there is a grounded fear of self-incrimination in the trial court, and there's an immunity protection that protects them from incriminating themselves, then the trial court is compelled to put them on the stand.
But why wouldn't you go question by question?
To determine whether it's a valid invocation?
No, to determine whether it's even a Fifth Amendment question. Like you said, you could say, what's your name?
Sure.
How old are you?
So
Do you have a family?
Right. So the law requires the trial court to just confirm that there is a valid invocation. That is not a heavy burden because
just saying that, did you give a statement to the police? You think that would be incriminating?
on the stand in front of the jury,
Did you make a statement to the police?
Are you asking if that question were asked in front of in the presence of the jury on the stand?
No,
or
I'm
during
talking about going through this whole thing to see what is valid invocation of the Fifth Amendment, because not every question, every answer is a valid invocation of every question is not a Fifth Amendment issue.
Correct. It's only a valid invocation of the Fifth Amendment if there is a possibility of self-incrimination. In this case, the trial court rightfully found that there was a possibility of self-incrimination.
And you're saying that if the prosecution would have granted, the remedy would be for the prosecution to grant full transactional immunity, and then there should have been a ruling for him to be compelled to testify.
Correct.
And then if he didn't testify, then there's contempt and in jail and everything else. But
Correct.
That's not what happened here. There was never full immunity granted.
Correct. And that is the only remedy available to the state.
Do you think the state could come back now and file something granting full immunity and ask the judge to reconsider this decision?
I think that would completely fly in the face of the purpose of Rule 12K. I think that sets a precedent that any time the prosecution gets a ruling from a trial court, and by the way, I don't consider this an evidentiary ruling.
But the judge made the ruling on that basis. She said,
correct,
there isn't full immunity here.
Correct.
And so now, doesn't the state have the remedy to say, hey, we are now granting full immunity, here's a filing saying so, and murder is not excluded, then wouldn't they be compelled to testify at that point?
I believe if that had happened before the 12K certification, yes. I believe that the 12K certifying to this court that it could not continue without this evidence, and it had the option to include murder in its immunity agreement before all of this happened. That exclusion is the sole purpose that we are here, and the state is the sole party with the authority to remedy that issue. Because the point is that nobody can physically or legally force a witness to speak and incriminate
Well,
themselves.
why couldn't the state dismiss the appeal today and say we're giving him immunity?
That's a great question.
I know, but you're saying that that wouldn't work, that wouldn't be proper, that he wouldn't be able to testify.
I guess for me, or what I'm trying to relay is that
I'm not trying to give you a hard time.
No,
I'm
I know
trying
you're
to
not.
figure
I know
this all
you're
out.
Trust me, I know. Yeah, I think when the trial court was alerted that Mr. Penson Willis could be incriminated, it did a valid inquiry. It was outside the presence of the jury, and it did not dive question by question because that would obliterate the entire purpose of the Fifth Amendment privilege.
But that happens all the time too, that they do a question by question in regard to whether, and how many times does a witness have to say, I plead the Fifth Amendment, I plead the Fifth Amendment, I plead the Fifth Amendment?
It is only a valid invocation if there is a grounded fear of self-incrimination, if it is not a speculative fear of self-incrimination. That's the distinction. And here the trial court properly found that there was absolutely a risk that Mr. Penson Willis could incriminate himself. If Mr. Penson Willis was compelled to take the stand, he would be forced to answer questions that could incriminate him in a murder case, which is the very case.
But if you did a question by question, the court could say, no, he's not allowed to answer that. It's a valid Fifth Amendment issue.
I'm sorry, I guess I don't understand.
Like, for instance, when I said, if you say, what is your name? And he says, I take the Fifth. And the judge could say, no, that's not.
Well, correct, that's correct, because that's not a valid
Answer the
invocation.
question.
Yes,
Okay.
that's not a valid
And
invocation.
then if, and then let's say I'm just trying to make this as obvious as possible. Then the state says, did you kill him? And he says, I plead the fifth. And she says, yeah, he doesn't have to answer that.
Correct.
So why couldn't the judge do it that way? Wouldn't that have been the more proper way of doing it in order to figure out what was actually admissible and what was actually subject to the Fifth Amendment invocation?
The immunity statute in Ohio requires the state to file a written request for immunity. The state did that, and the court deferred its ruling until it determined whether the invocation was proper. After the court validly determined that the invocation was proper, that it was grounded, it was not speculative, it was then the state's, their remedy was to offer an immunity agreement that was coextensive with the Fifth Amendment. They did not do that. They offered an immunity agreement that did not protect the witness from murder or complicity to commit murder. That was the entire subject of the case.
Counsel, can we talk about the state's motion for leave or as a right
Yes.
to prosecute this appeal?
Yeah, I think that in this case, when the state, in its motion for leave to appeal the alternative, the state told this court that the trial court did not compel Mr. Penson Willis to testify, quote, even after the state offered immunity for his responses to any questioning which removed the possibility of prosecution. That is a flagrant misrepresentation of what happened at the trial court. That is not what the immunity agreement said. The state in that motion for leave omitted the two most important words in that immunity agreement, excluding murder.
Can we discuss the issue of standing or finality as it relates to the state's motion
Sure.
to appeal?
Sure. The state has no standing to challenge a valid invocation of a Fifth Amendment right of a third-party witness.
Well, I thought the case law said that the state does.
In State v. Arnold, the Supreme Court says that a party does not have the ability to either invoke or challenge the invocation of a third-party witness's Fifth Amendment right. It's a personal right. It belongs to the person
But
invoking
the
it.
effect of it.
The effect of it only comes into play if it is a valid invocation, and here it clearly is based on the facts, based on the immunity agreement and the exclusion therein. The state does not have standing to challenge this in the first place. The privilege against self-incrimination is personal. It does not belong to the defendant, it does not belong to the court, and it does not belong to the state. And
So the defense attorney for the defendant was in error when he started talking about him having, the witness having an attorney, because he had nothing to do with that, right?
alerting the trial court that a third-party witness could incriminate themselves on the stand does not rise to an invocation of that witness's rights. And frankly, I find it illogical that the state takes issue with the trial court advocating for their client by pointing out a real, plausible alternative suspect to the jury. And trial counsel had a duty as an officer of the court ethically to alert the trial judge that there could be testimony that implicates this witness. He should be appointed independent counsel.
I'm going to direct you back to Judge Hensel. I'm sorry, I did not mean to get you going off in a different direction, because she needs her question answered in
Okay.
regard to the interlocutory nature of the appeal and so forth.
Sorry.
It's my fault, I apologize.
No, no need to. So we talked about standing. What about the interlocutory nature?
In this case, there's not a final appealable order available for the state to appeal. The court did not grant or deny that immunity motion. I think Mr. Raley, and I could have misheard him, but I think he said that the state denied that motion. That's not what happened here. And additionally, what happened is not an exclusion of evidence that Rule 12K contemplates. This was not an evidentiary ruling. The Fifth Amendment protection is not an Ohio rule of evidence. It's a constitutional protection.
But she did rule that people can't testify. They validly invoked their rights, but it does affect the state's case.
Correct.
And it's an exclusion of a witness.
And there is a one remedy and one sole remedy to fix that, and it is the state's sole, it is their remedy, and they're the only ones that can do it, is offer full immunity.
Well, there's also an administration of justice type of problem as well, right?
Yes, that's correct. If the trial court believes that compelling the witness would not further the administration of justice, then it does not need to compel that witness to testify. And in this case, the state is asking the trial court and asking this court to put Mr. Penson Willis on the stand and subject him to questions that could implicate him in murder and not protect him for those charges. And I just don't buy what the state is selling when they say that Mr. Penson Willis has no culpability in this crime because he was merely a witness. If the state believed that, they would not have excluded murder from their immunity agreement, and none of us would be here.
Well, but they say, and I mentioned that before, they say what's to prevent, that's why I'm talking to you about the precedents, and that is what's to prevent him from saying I killed him, and then he can't be charged, and the defendant is released.
I don't think there's anything that can prevent that, and I don't know that there's anything that should. I think that if the prosecutors are prosecuting one person and they need this statement, who, by the way, this witness said was a lie, that it was Mr. Williams, and that's who the state is prosecuting, and that is the thing that their entire case hinges on, then I guess that kind of calls into question the entire prosecution of their case and how they're operating and how they're bringing cases to trial. If that is the sole thing that their case depends on, is Mr. Penson Willis saying he lied when he identified Mr. Williams?
You're out of time, so if you could wrap up in about 10 seconds, we'd appreciate that.
At the end of the day, Your Honors, there is one remedy for the state to take. It is to give complete immunity to Mr. Penson Willis. Trial has already begun in this case. A jury has been impaneled, and to allow appeals to continue like this, mid-trial interruption like this, would completely compromise judicial economy, both in this court and the trial court, and it detrimentally prejudices the defendant's fair right to a trial. Thank you.
You'll have your full 5 minutes for rebuttal.
Thank you, Judge. I really appreciate the questioning today, and this is a very unique case, and I can tell we have a lot of legal standards we have to think about in the next couple of months and weeks. I will start with discussing some of these jurisdictional issues. I will start with the request for leave. I think the court may know that I use that belt and suspenders approach in very important cases. I do think I have a right to be here, and I'm going to address that in a moment. But for the belt and suspenders approach, I do think that the finality of the order has nothing to do with App Rule 5 or the statute 2945.67a. I point you to the case that I argued, and it's going to stick with me for most of my career, State versus McElroy, that was out of Lorain County. That was one that this court addressed one of these types of appeals before sentencing was complete on all of these cases. There was an unsentenced count. There was clearly a non-final appeal order in that matter. I'd also point out that the state has very limited rights after there is a verdict. I cannot appeal if there's a dismissal under Criminal Rule 29. I can only ask for a finger-waving decision from this court saying to a trial judge, don't do it again. We can't do that in a case like this where there's such an important matter in front of the jury. I'm trying to get the decision in the jury's hands and not to take it away from them. I will say I think Criminal Rule 12K still applies. I mean, this is something where the trial judge said, you cannot ask questions. We are done here. That is a restriction on the state's presentation of evidence. That means 12K applies and we're here as of right. Now, I would say that I really do think that this is about the invocation first before we get into any immunity issues. And I really disagree with the view that the invocation here was not speculative. Because if you look at the witness's own testimony, he speculates. What additional charges do you fear? I don't know. That's
a witness should not have to, in order to invoke a Fifth Amendment, be able to identify each and every charge that a prosecutor could make against them.
Of course not. And if there's a circumstance where there wasn't 5 prior explanations from this witness, I might be able to say, I don't know, doesn't mean too much. In a case like this where he's going through a variety of other reasons that clearly aren't a legitimate indication, and when in the middle of that colloquy, the trial judge herself says, that's not legitimate, essentially try again, that's a real problem. That's a procedure this court really cannot say, this is a great way to go about this is what we promote.
Is this witness also a victim in the state's position then? Because he witnessed violence and he was merely there?
He's not a victim in one of the counts, that's for sure. Their only victim that's identified in the indictment is TA.
Would he be a victim under Marcy's law?
I have not thought about that, Judge. I do not know. I would also point out the essential point of the legal standards around this is that a trial judge can't just rely on a witness to say so. And that's exactly what she did. I think that's something this court should reverse, go back, and we should try this all again. Thank you.
The court will take this matter under advisement and issue a written decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, our opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.